The Supreme Court on Monday announced that it would stay out of a fight over a restrictive North Carolina voting law. The move left in place a federal appeals court ruling that struck down key parts of the law as an unconstitutional effort to target African Americans with almost surgical precision. As is the court's custom, the justices gave no reason for declining to hear the case. But Chief Justice John G. Roberts Jr. issued a statement noting that there was a dispute about who represented the state in the case and that nothing should be read into the court's decision to decline to hear it. The law, enacted by the state's Republican-controlled legislature in 2013, imposed an array of voting restrictions, including new voter identification requirements. It was part of a wave of voting restrictions enacted after a 5-4 Supreme Court decision that effectively struck down a central part of the Federal Voting Rights Act, weakening federal oversight of voting rights. The case challenging the North Carolina law was brought by civil rights groups and the Obama administration. A trial judge rejected arguments that the law violated the Constitution and what remained of the Voting Rights Act. A 3-judge panel of the United States Court of Appeals for the Fourth Circuit, in Richmond, Virginia, disagreed. Continue reading the main story. Related coverage. Supreme Court rules Miami can sue for predatory lending May 1, 2017. The appeals court ruling struck down 5 parts of the law: its voter ID requirements, a rollback of early voting to 10 days from 17, an elimination of same-day registration and of pre-registration of some teenagers, and its ban on counting votes cast in the wrong precinct. The court found that all 5 restrictions disproportionately affected African Americans. The law's voter identification provision, for instance, retained only those types of photo ID disproportionately held by whites and excluded those disproportionately held by African Americans. That was the case, the court said, even though the state had failed to identify even a single individual who has ever been charged with committing in-person voter fraud in North Carolina. But it did find that there was evidence of fraud in absentee voting by mail, a method used disproportionately by white voters. The legislature, however, exempted absentee voting from the photo ID requirement. The court also found that the early voting restrictions had a much larger effect on black voters, who disproportionately used the first 7 days of early voting. The law, the court said, eliminated one of 2 souls to the polls Sundays when black churches provided rides to polling places. In September, a deadlocked Supreme Court turned down an emergency pre-election request from state officials to block the appeals court's ruling. Justices Ruth Bader Ginsburg, Stephen G. Breyer, Sonia Sotomayor and Elena Kagan voted to reject the state's arguments. Chief Justice Roberts and Justices Anthony M. Kennedy, Clarence Thomas and Samuel A. Alito Jr. would have temporarily reinstated parts of the law. In December, state officials asked the Supreme Court to hear their appeal in the case, North Carolina v. North Carolina State Conference of the NAACP, number 16833. 2 months later, in an unusual last-minute procedural maneuver, 2 newly elected Democratic officials, Governor Roy Cooper and Attorney General Josh Stein, asked the court to dismiss the state's petition seeking review. Lawyers for the General Assembly opposed the motion. In his statement on Monday, Chief Justice Roberts said the Supreme Court's decision to decline to grant the petition seeking review, or petition for certiorari, turned on that dispute. Given the blizzard of filings over who is and who is not authorized to seek review in this court under North Carolina law, the Chief Justice wrote, quoting an earlier decision, "It is important to recall our frequent admonition that the denial of a writ of certiorari imports no expression of opinion upon the merits of the case.